here on behalf of the International Business School. The legal profession swears by the sentence. Spoken words fly away, written words remain. Legal drafting is the most important instrument of a legal communication. A legal document must be drafted in a way that is, it specifies the legal issue, statement of the client, and the remedies sought technically. In order to provide us with the real insight into the drafting world, we have Dr. Abha ma'am with us here today. She was born in Jhansi to Professor Dr. Jagdish Sahai Kulshreshtha, who is 10 times Limca Book Record holder, and Srimati Kamlesh Kumari, a distinguished author and a music composer. Apart from holding a strong academic background, ma'am is an expert legal drafter. She is a MA, LM, PhD holder, and she has completed her MDIM from London. She is truly an epitome of knowledge. Before taking the session forward, I request our director sir to present the sapling and the memento to ma'am. International Business School was established in the year 2004. Gives its accredited to Guru Gobind Singh Inter University, Delhi, and is approved by All India Council for Technical Education, Ministry of Education, and Government of India for its management courses and law programs. It's Bar Council of India. The institute conducts of MBA, MBA International Business, BBA, Integrated BBA LLB, and Integrated BA LLB honors. Further, I would like to request ma'am to conduct a session.
Okay, ma'am, you want a collar mic or a hand mic? ये फिर collar mic is better. ऑन कर दीजिए.
Good afternoon to all of you, and it's my privilege to be here. First of all, I am thankful to the Institute, its director Dr. Nath, Dr. Yadav, and all the other faculty members. I had come earlier also. It was a very good experience to interact with you students, and today as the topic has been suggested, is legal drafting. Of course, legal drafting is very, very important in any of the cases in the court, whether it is a civil case, it's a criminal case, matrimonial, domestic violence, or anything, or property matter. I'm sorry the session has started late because of the earlier session which completed very late. But not an issue. I will try my level best to have some little drafting, practical part of it. Suppose I had 2 houses. I had my bank account with money in it. I have a farmhouse. I have my office. Necessarily, please always remember, will is not to be in favor of your children or otherwise. Will can be in favor of anyone. It is not necessary that you give your everything to your children, your sons, daughters-in-laws, or daughters, or whatever. It is your choice purely. Like suppose there are 3 sons. 2 sons are really taking care of the parents. 3rd one is not. So maybe the parents or the father or the mother who is writing the will may feel that I will give my properties to 2 sons only, not the 3rd. It has to be drafted very carefully in regard to the description of the properties. It cannot be I give 1 house to my elder son, 1 house to the middle son or younger son or something like that. The property has to be identified, like house number and all those things. If there are bank accounts or FDs or whatever, details of the bank and other things are to be given. Now, after giving the description of the properties and the names of the persons who are the beneficiaries under the will, it has to be very clearly mentioned. that first of all it has to be mentioned that this will is being executed, being in sound state of health, and mental and physical health. If any insane signs some paper, somebody gets signatures on a piece of paper by an insane person saying that this is a will and I inherit all the properties of this person, that is not a valid will. Because insane person doesn't know who has written or what has been written and what has been given to whom. So that cannot be taken as a valid will. So after writing down 1, 2, 3, 4 all the details about the will, the properties, assets, movable and immovable, the last part of the will is very, very important. The last part of the will has to be that this will is signed by the executor in presence of the two witnesses, and the two witnesses have signed in presence of the executor. If this clause is not there in any of the will, then this will is not maintainable legally, because this has to be there. Because what is the reason behind it? What happens when a person dies? One son goes to the court of law and says, this is the will according to which I am entitled to the property ABCD. Another will is there brought by the second son in the court of law. He says, no, the will is in my favor. So now there is a problem. Which will is to be taken into consideration? Of course, the law is whichever is the last dated will be taken as legally correct. Why? Because sometimes what happens, the father says, my elder son is good, so I execute will in his favor. But later on, the daughter-in-law doesn't behave properly and the second son is good, so he says, no. Now I write another will in favor of the second son. Now date of the will is very important. A person may have 2 wills, 3 wills, but the last dated will is to be taken into consideration and as correct. The problem comes when the 2 wills are there, both in favor of different beneficiaries, but dated same. Suppose it is 1st January 2023. Both the wills are same dated, but one in favor of one person, second in favor of another person. Now how to find out what is the matter behind it? Then the court of law will try to find out the signatures. Because certainly some of the signatures on one of the will may be forged. Now the matter will go to handwriting expert under Evidence Act. And the report of the handwriting expert will be taken into consideration to decide. But in the meantime, what happens? Long years are just wasted in deciding the genuineness of the will. So now this will part, whatever is there, the last part, as I said, is very important, that the will is to be executed in presence of the witnesses who have to sign in presence of the executor. Now, what about the registration of the will? We have Registration Act where it is specified what documents are to be registered and what documents are not to be registered. So the registration of a will is not mandatory under law. It is not to be on a stamp paper, it is to be on a plain paper and need not be registered under law. May or may not be. There is no legal requirement or mandate about it. Then you will ask why people go for registration of the will. The benefit of getting the will registered is, suppose the will is lying at home. So many people are coming and going at the time after the death. And the will is lying in the house. Someone picks up the will and finds that he or she is not the beneficiary. Maybe the person clears off the will and throws away. Why? If there is no will, then equal shares will be there. 3 sons, 1/3 each. And suppose it is a husband executing the will, then 1 share to the wife and remaining shares to the children, 1/4, 1/3, whatever. So therefore registration of will is there, because if anybody has any idea that the will was registered, one can go to the registrar's office and find out and take out a copy of the will, which is a genuine document which is registered. So certainly registered will has some more effect than as compared to the unregistered. So any question on this? So I go forward. Any clarification? Is okay? Should I proceed further? Now we come to affidavit. I am just giving you the practical things because the time is, I have to leave at 3 o'clock. So This is affidavit. Now, affidavit, the drafting is same, but they are to be used in two ways. One affidavit is which is to be filed in the court of law along with the suit or writ or any application. Another affidavit is, I'll give you an example. When you took admission here, you must have given an affidavit, anti-begging affidavit, right?
Right.
Or if you want to, if some correction in date of birth or something, you have to give an affidavit. So many types of affidavits you have to give. Those affidavits, you write the contents 1, 2, 3, 4. Then, after the contents are there is a verification part. Verified at Delhi on this day of September 2023 that the contents of the above affidavit are true. Then you write deponent and two places you have to sign. Above document, deponent. Now, this affidavit what you have to submit in the institute or anywhere else or some DDA or municipal corporation of Delhi or somewhere in regard to anything. That affidavit has to be attested by notary public. Where the we are notary public and oath commissioners appointed by the court, and there is a list of notary public and oath commissioners, and you can go to any oath commissioner or notary public. In the first case, notary public, who will sign your affidavit and put a notarial stamp 3+2, that is 5 rupees notarial stamp, and he will put the stamp also, signature also. Then he will get your signature on the register that this day you had given this affidavit for attestation. Now the other affidavit what I am talking about, which is to be given in any court of law supported by any application or writ petition or whatever document. It is to be attested by oath commissioner. It cannot be attested by notary public. Otherwise it will not be valid. So what you write in the affidavit, the contents what you want to write regarding this institute or regarding, it's a short affidavit in the court of law also. Like you have filed a petition for divorce. So I'll come to the petition, the contents of the petition in the other session, just simply to tell you about it. When you decide the contents to be mentioned in the matrimonial petition, divorce petition, section 13, 1, 1A, whatever, mental cruelty, physical cruelty. 1, 2, 3 for all the factual situation is mentioned in the petition itself, right? Then you come to the end of the petition and you ask for the prayer clause. A decree of divorce may kindly be granted in view of our facts and circumstances. The petition ends. Now, an affidavit has to be attested and filed along with this divorce petition. What is that affidavit? Very short. Before the so-and-so judge's name and all, party's name, date of hearing, affidavit. I so-and-so, deponent hereby solemnly affirm and declare that the contents of the accompanying divorce petition are may kindly be read as part of this affidavit, which are not being repeated here for the sake of brevity. That is the simple affidavit. Verification part, same. Contents of the above affidavit are true and correct. Nothing has been concealed therefrom. That is the affidavit, but it's a legal requirement. You have to give it. Now, we talk of the writ petition. You file any writ petition under section 22, 26, 27 of Constitution of India, article, I'm sorry. Then again also along with the writ petition, you have to file an affidavit. When you file a writ petition, the other party will file a counter affidavit. So there, because you are filing a counter affidavit, therefore no separate affidavit is to be filed. Because the name of the reply what you file is counter affidavit. And the reply to the writ petition has to go by way of counter affidavit. So therefore, you make out the counter affidavit and in the end, again the verification part, not the separate affidavit. So this is about affidavit. Now, coming to an agreement. I'm just giving you a cursory idea of the things. Now if you go to for an agreement, suppose it is a rent agreement between a landlord and a tenant. Now tenancy period has to be decided. First of all, you will write so and so, son of so and so, resident of so and so, aged about so and so. Hereinafter called party A. Because in the agreement again and again if you write all this, it will be very, very bulky. So for the short we say party A. And the agreement is between A party, so and so, son of so and so, say particulars, here in after called party B. Now the terms and conditions of the agreement. A is the owner of the property, flat, floor, whatever, consisting of so many, blue plan of course will be attached with the site plan, and blue plan of the property being tenanted will be attached as annexure, and then the terms and conditions will be written. For how many months? What will be the rate of the rent? It is including or excluding the electricity and water of the premises to the landlord. Regarding any mystery for disconnecting water or electricity supply, sometimes the tenants do that. That is punishable and cannot be done by the tenant. So all these terms and conditions are to be maintained and written in the agreement, and the rent of the premises will be given between 1st and 10th of every month in advance, and some security if taken 1 lakh or 50,000 whatever, that will be kept with the landlord, and at the time of vacating the premises the security deposit will be refunded to the tenant. So these are the terms and conditions in any agreement. So this is an agreement regarding landlord and tenant. There can be an agreement regarding loan, that I am giving you loan, this will be interest, and you will be refunding the amount of loan in such and such time and 6 months or whatever. If you don't do it, interest will be there. So you have to decide whatever you want to write in the agreement, the terms and conditions regarding the subject matter of the agreement. Now, not in India, but now I have heard that it is started in India. I am not aware of any practical case. But in foreign countries, there is a matrimonial agreement as well. Yeah, where the people have a matrimonial agreement that if the matrimony this doesn't continue for such a long time and we are not able to cope up with the temperament of each other or something like that, the husband will do this and the wife will do this or something like that. So this is the type of agreement. I can give you an example of Muslim marriage, where there is an agreement, I suppose, that this is some amount which is to be given to the wife if the man divorces, which is called meher. So that can be taken as a condition of giving a divorce to a Muslim wife. Why? Provision of maintenance is always there only because of the sustenance for the wife and children if any. So therefore this meher provision in Muslim marriage is also part of agreement or condition, you can say. Not an agreement in fact, but it can be condition as well, that you have to give this amount at the time of divorce. So that is there. So this is about agreement. Now these are the out of court draftings what you have to give, and I think before I proceed further, you people decide among yourselves to make a group of 4 or 5 as directors are asked me to do it, and whatever I give you assignment, when we meet in the next session, that assignment you will do, all of you. So I give you different assignments to different groups. So you can do out of the what we have done today, out of that I will give it to you. Then in the legal drafting also, we have, this was apart from the Court of Law, will implement partition deed. Partition deed is a partnership concern. There are 3 partners or 2 partners, and they have to have a partnership deed in the business, because what will be the capital gain, what will be the profit sharing, so who has how much share, so 1/3 each or 70-40 or something like that. So it has to be decided and written down very carefully in the partnership deed. Outgoing partner, what are the responsibilities? Incoming partner, what are the responsibilities? Because partners may keep on changing, and sometimes the ladies are also made partners, like sleeping partners. What are their rights? So, and if a partner leaves, what will happen to the liabilities? Because it cannot be there is huge liability, and then the partner says, I have nothing to do with this, I am just leaving, I am quitting. I am no more the partner with your firm now. So it cannot be like that, because every profit and balance accounts have to be taken care of, and then liability has to be decided and paid off. Then only a partner can leave. Otherwise, you will find many cases going on with the courts of law because of these partnership problems. Then we have trademarks. Trademarks agreements also, that this is part of this is part of this is my trademark, and you will not, similar, contesting companies, like footwears. And the footwears, similar name. Like when we had Eveready cells, similar red cells, pencil cells, they made it with the name of Everyday. And it just look like you are going in to towards Shahada, and when you cross Srinagar, red light areas, not that's red light signals. Children are selling water bottles, and similar type of bottle white with green flap is there, which is not Bisleri, it is Birseri. When it is the bus over, hardly any time because it will get free, you simply get hold of the bottle and pay the price. It is not Bisleri, it is Birseri. I have seen with my own eyes. And then there can be a case about it. So if there is a rival concern, you can have an agreement between yourself that you will not do this, because this is part of my business, this is part of your business. Like JK Tire case is going on, where I am a party in High Court. It is some lubricant which was being made by JK Tires. And in fact, it is the product of JK Tires only. And two persons, husband and wife, and another concern, they started selling off in the name of JK Tires with a little bit change. So it is 2000 pages petition pending in the High Court. Day before yesterday it was listed. Because of violation of the trademark. Everybody looks at it and says this is JK Tires and buys it. It is 1/10 the price. And it is not giving any results. Then people came to find out what is it. It is not lubricating. It is disturbing the machine, the system. Then it was found out that it is not JK Tire lubricant. It is something else. Now, all the four parties are there in the case and we are contesting that case. Of course, I am at the losing part because my clients, it's a legal aid matter entrusted to me by High Court. My clients have done it, this wrong practice, they have done it in Chadra and they were selling it. And they have the photographs of the original JK Tire company has photographs of these husband and wife selling it for half the price. And all the photographs, almost 500 photographs are there. So it's I said it is 2000 pages petition. So now it will be decided later on. Of course, I am going to lose it. But then, what to do about it? Right to contest, that's it. Because I have been interested by legal aid. So whatever case is interested, I have to fight it. Whether it is a weak or winning case.
Similar now, Bikano and Bikaji.
Bikaji, yes. These are the things where the violations are there and the normal people doesn't know about it. They just see the packet and purchase it and eat it. Especially when they are traveling from one place to another, and especially in buses and trains and all that, those things. Of course, even the people going by road in the cars also buy this on dhabas and here and there. So those types of agreements are also very, very important. Arbitration agreement. These are all the agreements what I am talking to you, or documents which are outside the purview of the court of law. Court of law is the petition, what I will discuss in the next section. Now, this what I was talking about, this, what was this agreement I was talking about? Arbitration agreement. Two people are fighting in the court of law for any reason. Now what happens? There is an arbitration clause that in case of any dispute, the matter will be referred to arbitrator under Arbitration and Conciliation Act. Now who will be this arbitrator? We have many, sorry?
It can be decided by the parties.
Yeah. Sometimes it is to be decided by one party. Sometimes it is to be decided by the other party. But it's not whims and fancies that I will decide or you will decide. It has to be written in black and white. Or as per the joint request of both the parties. Mutual consent, that is very important. Because I will have the arbitrator of my choice. You will have arbitrator of your choice. So how to go for it? It has to be by mutual consent. And in
Sorry to disturb you.
yeah, no, it's okay.
मैंने पढ़ा था कि third arbitrator, presiding arbitrator भी को.
I'm coming to it. I'm coming to it. Suppose there are two arbitrators and both differ. Then it has to be referred to the third arbitrator. Then it has to be referred to the third arbitrator. Like in High Court, two judges bench is there, double bench, and both the judges differ. Then the matter is referred to the three bench judge. Or even in Supreme Court, it's a three bench, five bench, seven bench, and very important matters of national importance or otherwise very important full court. Then they have to be referred to the full court. Like under industrial disputes, and there is a very peculiar situation where what is industry, what is not in industry. Till now it has not been decided by Supreme Court. It was in 1982, full court was there, which wanted to decide, but for some reason or the other, it's 84-86 page judgment. Not judgment in fact, it's only a direction. Till now it has not been decided, and it has been left open to a further full bench whenever it sits. But that it feels that the courts feel that that is not very important, because prima facie people know what is industry, what is not in industry. But sometimes there are problems where the labor courts are not able to decide what is industry, what is not in industry, because it is the nature of working. So whether temple is a industry, whether Tirumala Tirupati is a temple is an industry, whether Padmanabh temple is an industry, whether this Sai Baba temple at Shirdi is an industry, it's very difficult to decide. So it is still left open, where the courts also are in a problem, advocates are also in a problem, parties are also in a problem. But if there is an agreement of arbitration, it has to be deferred. You cannot go to the court of law unless and until arbitration clause is decided and it is taken care of by the parties concerned. When there is an arbitration agreement, an arbitrator sits and gives its arbitration award. When the arbitration award is there, it has to be filed with the court of law for its acceptance. Then and there, if it is not, some problem, objections are to be filed, and finally if it is decided in favor of one of the parties or the other party, then only the other avenues are open for the person concerned to go and challenge the award of the arbitrator. So this is an arbitration agreement also. Any questions till now? Anything which needs clarification in order? Yeah,
Can
please.
you explain about cross affidavit?
What is that?
Cross affidavit.
Cross affidavit. Yeah. I'll give you an example. In a matrimonial case, Justice S.N. Dhigra, for the first time, passed an order in matrimonial case. What was a matrimonial case? Firstly, let me give a background of it. There were persons, you remember Justice A.S. Verma, Chief Justice. When he, just before 2 days of his retirement, he passed the order that live-in relationship is legal. Right? What happened thereafter? It was earlier. Few years later, one lady who was in live-in relationship with a person, she went to the court, matrimonial court, family court, and asked for maintenance from the partner. That I lived with this person for so many years, and as a live-in, and we were living like husband and wife. Of course, we don't have any children, but then now I have been kicked out of the house by my partner, and I should get the maintenance. And he is earning this much, and the rule by the court is that 30% of the earning of the husband has to be given by way of maintenance. Of course, to the wife only. It will increase if the children are there, 1, 2 or 3, depends, and they are with the wife. Accordingly, the maintenance amount will increase. So he was earning this much. The partner came and said that no, I am not earning this much. I am earning only this much. Justice Dhigra says, no question of maintenance. It is a reported judgment. Live-in relationship is coming in and walking out. There is no marriage. Therefore, under section 24, Firstly, you have to establish that you are his wife. Even under section 125 CRPC, so no maintenance. You cannot ask for it because it is only wife or the father, mother, or whatever, parents. But we are talking about wife only. Even you can't go in 125 CRPC. Even you can't come in section 24 for maintenance parental right. Then she said, where should I go? He says no. No maintenance to be granted. You just walk in as per your choice. But she said, I have not walked out of my choice. I have been kicked out. Then he says nothing good. It's okay. It was an arrangement between you two. It was workable, it is not now workable. So no maintenance was granted. But this is a fact. But the importance of this case was that a guideline was given by Justice Deegra, which is maintainable till now. In every case maintained to be. He gave an instruction and guideline that whenever there is a matrimonial case, whether it is divorce, whether it is restitution of conjugal rights, whether it is declaring the marriage as void, null and void, or voidable, or maintenance. Especially for maintenance, he has given preference to it. Why? Because divorce will be granted on the marriage and demarriage of the case. But maintenance is by and large to be granted to the lady. Even if she is working, husband and wife both are working, even that maintenance is to be granted to the wife for children at least, not for herself, if children are with her. So therefore, every case was being watched very carefully. When you come into practice and you do matrimonial cases, you will find out. Yeah.
मैम जब हम पैटिशनर से क्वेश्चंस करते हैं तो उससे क्यों इसलिए आपने कहाँ पे किया इससे ज़्यादा क्वेश्चंस नहीं होते हमारे डिफेंस के पैटिशनर से
क्यों नहीं होते? I am cross-examining witnesses for hours together.
मैम
More than 200 questions.
मैम ज़्यादा क्वेश्चन बन नहीं पाते
किस केस की बात कर रहे हो आप?
मैम अभी फिलहाल में जो अभी जो आया था एक्ट तो मैम उसमें ज़्यादा क्वेश्चन बन ही नहीं पाए
नहीं कौन सा है? किस केस की आप बात कर रहे हो?
109
एक्ट कौन सा?
थोड़ा सा ब्रीफ में बता दो
या केस के फैक्ट्स बता दो।
मैम अभी उतना स्टडी नहीं करा मैंने थोड़ा सा करा था
ऐसा नहीं है आपका जब आप क्या होता है आप सोच के आए आप केस के हिसाब से क्रॉस तैयार करके लाते हो ना क्वेश्चंस बैठ जाओ 1 2 3 4 आपने कहा मैं ये पूछूंगा ये पूछेंगे आपने एक क्वेश्चन पूछा लाइक वन ऑफ द जजेस आस्क्ड मी कि मैम आपको क्रॉस एग्जामिनेशन में कितना टाइम लगेगा मैंने कहा आई डू नॉट नो नहीं बोली व्हाट इज दिस आंसर चिढ़ गई व्हाट इज दिस आंसर शी वाज वेरी रूड टू मी आई सेड मैम आई एम एग्जैक्टली टेलिंग यू आई डू नॉट नो हाउ मच टाइम आई विल टेक तो आपने फाइल नहीं पढ़ी मैंने कहा मैंने पढ़ी हुई है आई हैव ड्राफ्टेड माय क्वेश्चंस तो फिर बता दो इतने क्वेश्चन में कितना टाइम लगेगा मैं कल नहीं बता सकती मैंने एक क्वेश्चन पूछा सीधा जवाब आया इट्स ओके अब वो जब आपका सीधा जवाब नहीं आया तो 2 क्वेश्चन और निकलेंगे
उसको जवाब निकलवाना
हाउ कैन आई डिटेक्ट कि कितने देर में होगा चुप हो गए बिकॉज क्या होता है मोस्ट ऑफ द जजेस जो प्रैक्टिस करके जज बनते हैं दे नो द सिचुएशन और जो डायरेक्ट जज अपॉइंट होते हैं ना वो एडवोकेसी का नहीं पता होता तो वो सोचते हैं बस सवाल पूछे हो गया जैसा इन्होंने मैडम ने भी कहा ऐसा नहीं है आई एम रिप्लाइंग टू योर क्वेश्चन इट इज नॉट यू हैव टू फिक्स टाइप ऑफ क्वेश्चन मैरिज पे आप क्वेश्चन बना लोगे अपने है ना आपको हिंदी ज़्यादा कन्वीनियंट है और यहाँ बैठो मैं नहीं कहा हमको बैठे सपोज देयर इज अ पेटिशन ऑफ 40 पेजेस मैट्रिमोनियल पेटिशन है डाइवोर्स की है अब मैं आपको एग्जाम्पल देती हूँ डाइवोर्स पेटिशन कहाँ से शुरू होती है शादी इस दिन हुई थी बच्चा इस दिन हुआ दूसरा बच्चा इस दिन हुआ 2005 में शादी हुई थी 2006 में सास ने तंग करना शुरू कर दिया हस्बैंड ने तंग करना शुरू कर दिया एलिगेशन तो यही होंगे ना इन-लॉज ने तंग किया ननद ने तंग किया वो गाने देती थी फलाना करती थी सारा काम घर का करवाते थे कोई सर्वेंट नहीं था यही सब भी होते हैं ना एलिगेशन जनरल एलिगेशन यही होते हैं खर्चा नहीं देते थे खाना नहीं देते थे बाहर नहीं जाने देते थे हस्बैंड के साथ नहीं पिक्चर जाने देते मुझे गिफ्ट नहीं देते थे फलाना नहीं करते मेरा बर्थडे भी सेलिब्रेट करते Do you know what happened today morning? I read the news. वाइफ ने बोला it is in the NDTV.
Yes ma'am.
वाइफ ने बोला मुझे दुबई लेके चलोगे बर्थडे पर मेरे हस्बैंड ने कहा मेरी बहुत इंपॉर्टेंट मीटिंग है बाद में चलेंगे She has murdered him.
Yes, ma'am.
This is today's news. This is just an example कि matrimonial cases में क्या होता है. Not to the extent of murder. Not to the extent of murder, but cases नहीं होते. Murder तक पहुँच जाते हैं. कर नहीं पाते. That is a different issue. अगर ये पूछे कि ये हस्बैंड वकील साहब बोलते हैं तुम्हारा हस्बैंड बिल्कुल सही नहीं है और आपको देर से घर आता है, तो वाइफ ने बोला नहीं वो तो टाइम से घर आ जाते हैं. चुप रहो, मैं वकील हूँ कि तुम्हारा हस्बैंड और अफेयर चलाता है, उसका नहीं वो तो किसी की ओर देखते हैं. चुप, वकील मैं हूँ तो. This is the way how the advocates make the allegation to strengthen the case because they are also duty bound to protect their client. अब coming to your question, 40 पेज की पिटीशन है जिसमें डेट वाइज लिखा है रक्षाबंधन पे ये हुआ, दिवाली पे ये हुआ, दशहरे पे ये हुआ, करवा चौथ पे ये हुआ. 80 पैराग्राफ्स.
Yes, ma'am.
अब आप जब उस पर क्रॉस करना शुरू करोगे, सपोज यू आर फ्रॉम द हस्बैंड साइड, वाइफ के एलिगेशंस है, तो आप एक एक पे पूछोगे कि नहीं पूछोगे?
हाँ जी, बिल्कुल.
तो क्लेमेंट कैसे हुई आपके क्रॉस एग्जामिनेशन?
हाँ, हाँ.
नहीं हुई ना?
नहीं.
एंड नो कोर्ट कैन स्टॉप यू फ्रॉम क्रॉस एग्जामिनेशन.
मैम डिफेंस जब हम करते हैं तो सेकंड राउंड में हमारा डिफेंस का हो जाता है.
हाँ,
तो
आप रिटन स्टेटमेंट फाइल करोगे.
यस मैम.
क्लेम पे आप रिटन स्टेटमेंट फाइल करोगे.
मैम डिफेंस में हमें फर्स्ट राउंड में अपने विटनेस को बुलाना चाहिए.
नहीं
सेकंड
नहीं नहीं नहीं, डिफेंस में तो आप सबसे पहले रिटन स्टेटमेंट फाइल करोगे.
ओके.
वो सब मैं आपको नेक्स्ट सेशन में बताऊंगी. फिर एप्लीकेशन फाइल होगा विच इज कॉल्ड काउंटर रिप्लाई विल जॉइन द. उसके बाद इश्यूज बनेंगे, उसके बाद डॉक्यूमेंट्स फाइल होंगे, उनका एडमिशन डिनाई होगा. उसके बाद डाउन द स्टेज कम्स ऑफ द पिटिशनर्स विटनेस.
ओके.
लिस्ट ऑफ विटनेसेस फाइल करेंगी दोनों पार्टीज. फिर पेटिशनर का जो है जो वाइफ है उसका शुरू होगा. सपोज इट इज अ वाइफ पिटिशन, वाइफ का विटनेस होगा, उसके फादर का, मदर का, ब्रदर का, जिनका भी जिनको वो बुलाना चाहती है उनका होगा. जब उनका एविडेंस ऑफ क्रॉस खत्म हो जाएगा, 4 विटनेसेस है 5 है, तब आपका शुरू होगा. फिर हस्बैंड, उसके माँ पिता, भाई बहन वगैरह एज पर लिस्ट ऑफ विटनेसेस, फिर उनका खत्म होगा. उसके बाद फिर जाके केस आपको मिक्स मिलेगा रिटन, ओरल और बोथ. उसके बाद कोर्ट पास होगा. दिस इज द स्टेप्स. बट जैसे मैंने आपको 2 मिनट में बता दिया, 2 मिनट में होता नहीं है. हाँ, इट टेक्स इयर्स because one of the divorce petition
Yes,
which
ma'am.
order I I got last year only, it went on for 18 years.
मैम जब केस एंडिंग
The name of the case is Bhushan Kumar Kundu versus Sharmila Kundu, decided after 18 years, after marriage of 30 years.
18 years.
18 years. 18 years.
They could have waited 18 years for I don't think they would have waited.
अलग रह रहे थे, वो शादी के पास की अलग रह रहे थे. नहीं, वो लेडी कहती थी मैं कुंडू सरनेम नहीं छोड़ूंगी, डिवोर्स नहीं लूंगी, मुझे कुंडू लिखना है. मैंने कहा मैं तेरे को कुंडू लिखने नहीं दूंगी. अरे बहुत लड़की की कोर्ट में was a really a tough case for me. अभी डिसाइड हुआ लास्ट ईयर. 3 लाख मेंटेनेंस मांगा था अंडर सेक्शन 24 पर मंथ.
Per month?
पर मंथ 3 लाख. आज शुरू तो पिटीशन पढ़ के आप हंसोगे. शोफर ड्राइवर गाड़ी और पार्लर का खर्चा 20,000, मेरी बेटी का पार्लर का खर्चा. आई कैन शो यू ब्लैक एंड व्हाइट. मेरी बेटी के पार्लर का खर्चा 15,000, मेरे बेटे का जिम का खर्चा इतना, मेरी मेड 20,000 की, और मेरा ड्राइवर इतना, और हाँ इंटरनेट और वाईफाई पता नहीं क्या क्या, वो सब करके 3 लाख.
But it is according to the standard of living of that person.
Yes,
Maintenance.
because both the partners have to live at the same standard. Please, both the partners have to live as per the same standard. It cannot be that husband is earning 4 lakhs or 5 lakhs a month and she says, I give 500 rupees. No, it is to be decided by.
And ma'am,
Ma'am,
wife is
but
also.
if we remove the standard of living aspect from maintenance, because
Yes.
this is has been a question of discussion among the advocates specifically. I'll not say the judges, but the maintenance, obviously the advocates from the husband side often face this issue. That when the maintenance is fixed at the level of life or at the standard of life that the wife was having prior to that, obviously prior to that,
Yes.
then won't it change or deny the meaning of the word maintenance? Because we say that maintenance is to meet the needs, not to go to the wants. I think
Yeah.
as judge has also observed.
You are very right. You are very right. I give you the practical example of today. What is a Manya today? She says I will have 75% of the assets. Is it maintenance? Is it maintenance? They are running into late 50s, both of them. Now the father has come to the help of the daughter-in-law and said, "इसने मुझे भी घर से निकाल दिया," and he is like that. The father-in-law is favor of his daughter-in-law, and now she is saying 70. It has almost been signed. That is also an agreement. Singhania's agreement is also an agreement. 75% of the assets of the Singhanias. That is being finalized. I think it has been finalized. So this is what is this? Is it maintenance? She herself is well established. She was one of the directors of the company. And all the shares have crashed because of this difference in army assets. So this is type of thing. So, madam, your question and answer, have I satisfied you?
Yes, ma'am.
Any other question by anybody?
Ma'am, my question.
Yeah. No, it's okay.
Not take much of the time.
No, it's okay. I'm here up to 3:10.
My question is regarding ma'am 138. Specifically, not talking about the petition or the complaint that we have filed, NI Act 138.
Yeah.
Ma'am, many a times when we are drafting legal notice to be sent to whoever we receive notice from the drawing. And obviously the notice check and bounce.
You members, please, will you please maintain silence? Can I expect silence from the audience? We are in the midst of discussion and something useful for you people is being discussed. So you cannot ignore the things like this. Until and unless you have something more important than this. And if it is more important, let me also know. I will also share. Yes, please. Sorry.
So what are the essentials? We all know that some of the facts are to be included when the check bounce, what is the check number, which bank, why dated and all that. But there must be some key factors that one has to keep in mind, because we obviously see in many of the cases, a lot of advocates admit to the signature in the notice only that we did this, which loses half the case. Because there is a presumption again in the NI Act on which Supreme Court even commented upon. Any little bit of set prefix on that we can.
See, I get it. I have more than 200 NI cases.
Exactly.
What happens is, the moment you deposit the check in the bank, and the moment it is bounced, there's no limit when you can give a notice. You can give a notice.
बार-बार उसको bounce कराना.
नहीं, you can give a notice. You have to be vigilant about the case. You give a notice which is served or not served. Now even the High Court says it is electronic. You can send on email and WhatsApp. Now the Supreme Court says no WhatsApp.
Okay.
Only email. Or registered email or speed post. No other method. Earlier it was in WhatsApp. एक टिक हो गया, एक टिक हुआ तो चला गया, दो ब्लू टिक हुआ तो सर्विस. Court says no blue ticks. We don't accept this in WhatsApp. It is only the email of the person concerned or the speed. It is always better if you want to make some announcement. Yeah.
Students in the middle. Excuse me.
Okay. So you give the notice, legal notice which is served. At the moment it is served, it is the 30, 15 and 30 days. You give a notice and then you wait, and then if reply is there or not, no reply is there, you file a case, complaint case under 130. In the notice you have only to mention, first of all you have to justify what amount was given and how, whether it was cash. Sometimes your friend asks for 10,000 rupees. In a case of need, you just take out and give 10,000 rupees. Of course, he is your friend. No written acceptance or no written receipt or something like that. Out of friendship, you will give this.
But वो तो फिर provision आएगा नहीं.
आता है. Along with
possible date.
No, I'm coming to it. And now suppose I'm giving you step by. And now suppose he asks for that. मुझे 20,000 और चाहिए. You give 20,000 more, but now you say, please sign an acknowledgement. Then it comes. If it is a promissory note, it comes. If it's a Hyundai, it comes. This honor. Now you say, I won't give you more money unless you give me a check, whether it is post-dated or whatever. He issues you a check in regard to repayment of the amount. Which check has been issued. Now, in the notice you will write that initially you had taken 10,000 on such and such day, 20,000 on such and such day, then you had accepted it on a piece of paper under your signatures, and towards repayment You gave me a check of 150 because in the meantime you were taking 1 lakh on through check. And in repayment of that thereof, you have given me a check which has been dishonored. So within immediately you give me my check amount or I will go to the court of law. He doesn't give a reply, he doesn't give you the money, and you go to the court of law. When you file a complaint before the Metropolitan Magistrate under 138 NI Act, copy of the original check is intimation of dishonor from the concerned bank, your bank memo, and your, because that's very important, because filing has a limitation. And then you have to give the legal copy of the legal notice, any correspondence in between or whatever. Or if you have telephonic conversation recorded, anything you file it. And immediately there will be notice to the concerned person. Now, what happens when they come to the court of law? The first thing is, 99% of the cases of my administration, I have given a security check.
Very same defects all the time.
I have given a security check. I have given the amount back, 1,50,000, and I asked for the refund of the check, which has not been given by the party intentionally and deliberately, and it has been misused. Therefore, I stopped. That is the case in most of the cases. The first difference what I took out, is, in my cases at least, I do not know what are the other cases. I said yes, I am out of the court. I will not claim anything. Just tell him by what way he refunded me the amount. Was it a cash? Was it in front of anybody? Any witness to that? Or he transferred through RD? Any amount details? No. The reply to anything is no. So he is caught now. And I have moved an application under the 91 CRPC to catch hold of the diary by the court and send it to the forensic department. Because names have been added in different things, different pen later on. So the age of the ink will prove. So now the moment the order comes out is fixed for final arguments. The moment the order comes, he will go to jail. And put an application under 340 CRPC also. So now let us see what happens. I mean, these are the things how the people are behaving. So in 138 cases it's very difficult to do. Because 99% of the cases, whether it is mine or yours or anybody's, it is security check. The advocates from the accused side have taken only one defense. It is a security check. Forgetting about the fact, how do you prove that it was a security check? That is a problem.
Being narrow-sighted.
Yeah, because the transport companies and all, also, you know, there are so many cases, thousands of cases of dishonor checks. माल चला गया, payment हो गया, और check दिया, माल भी ले लिया, और check दिया, it is being dishonored. So most of the cases are regarding the transport companies. That is it.
And ma'am, from the accused side, if all the details are there, like you are saying that no details are there, every answer is there. Like you are saying now, while maintaining the diary, there is no details.
Yes.
If the details are there, then what is the next step to that?
I have given the application under 91 to take hold of the diary by the court and send it to the forensic science. He has given all the replies in my favor. In fact, he has lost the case. Now only the formal order is to be passed. That is it. Because he has admitted, and he has also admitted that he was running the committees to the tune of 5 crores. 6 committees, 5 crores. And he has also admitted I have not paid any income tax on that. I have not filed any income tax returns also. 5 crores, no income tax. No tax has been paid on this amount of 5 crores. So where he stands now? So that is how you have to cross-examine and build up your case. That is the only thing. So every case depends what you have to answer and how you have to answer. So I mean, somebody in the class has to take responsibility of making the groups. Yeah, you make it later on, and then please note down what assignment you have to give to the groups. Affidavit, will, agreements, all types, you know, arbitration agreement, this thing, and then yeah, I just forgot to tell you, living in between. I was talking about justice as a thinker's judgment, live-in relationship. And of course the maintenance was not granted. But the guideline was given that detailed affidavit, it is running into almost 28 pages. It runs into 28 pages. Every party, husband and wife, whosoever files a counterclaim, means one is the petitioner, other is the respondent, husband, wife, whatever. Both the parties have to file detailed affidavit in regards to their particulars. Not only holdings, name, father's name, I can give you a format of it, address, mobile number, landline number, any vehicle, if, what car, what make, which year, and then whether any Wi-Fi connection and all those things, rented house, any bank accounts, FDs, then insurance policies, then mutual funds, then how much being paid on electricity charges, how much being paid average monthly charges, where are the children studying, private school, what is the fee, which class, and name of the principal, location of the school. Then this type of, it is running into 28 pages and having almost more than 100 items, what both the parties have to answer. That is the income of affidavit of assets and income. So that is very important, and the courts have, unless you find that, the court will not hear the further proceedings. So that is very important. So now we were there on affidavit, will, and then agreements, partnership agreements, and arbitration agreement, landlord-tenant agreement, matrimony also you can have. What all we discussed? Arbitration, trademark. Arbitration agreement. So you can divide yourself into groups and do the homework on this. And next time when we meet, I will start with the, which is more important part, drafting in the legal petitions, like the writ petitions and KBL. Writ petitions also 5 times you must have heard all those. We'll hear about it. Thank you very much for patient hearing.
Informative session. Now I would request Dr. Sonia Rajoria, faculty coordinator, to extend a vote of thanks to you.
पोडियम में माइक नहीं चल रहा नहीं अब गए दो कॉलर माइक लगा दे मैंने पोडियम में माइक के ऊपर
I extend my heartfelt gratitude to each one of you for being a part of this magical event. Your presence has added immense value and warmth to the occasion. I would like to express my deepest acknowledgement for Dr. Abha, whose support and commitment was invaluable. Thank you so much, ma'am.
Thank you, ma'am.